This is an appeal of a matter of Vehicle Control Services Ltd and Carr.
Your Lordship, my name is Jackson. I'm representing the appellant.
Yes.
And I have Mr. John Craigs representing the respondent, my lord.
Mr. Craggs. Yeah.
Craigs, sorry.
Yes. Yes.
Yeah.
Yes. Thank you, Mr. Yamba. We've got your skeleton argument, and we've read the papers. And at this stage, we'd like to hear first from Mr. Craggs, please.
May I confirm, my lord, that my skeleton has also been received?
Yes. Yes, just the one last year.
Yes, indeed.
Yes.
Back in September, I believe.
Yes.
Yes. So, essentially, my lord, the crux of my submissions are set out in the skeleton argument. This, of course, is an appeal against the decision of Her Honour Judge Evans upholding my client's appeal against the set aside of a judgment entered in default against Mr. Carr back in 2019.
Yes.
Now, the appeal was from a judgment of District Judge Iyer, I hope I'm pronouncing that correctly, wherein the judgment against the now appellant was set aside on the basis that service of the claim form had been defective, essentially.
Yes.
The issue was that the appellant was residing, he claimed, in a rented property where the parking charges were issued, having moved out of the service address, which is a former matrimonial home. The major element of DJ Iyer's judgment that was appealed was the conclusion by him that 2 phone calls by Mr. Carr to the respondent constituted notice that he had vacated the service address.
Combined with the fact that many other communications had not been responded to.
Yes, indeed, my lord. That was certainly the combined evidential landscape that DJ Iyer utilised to reach his decision. In respect first of the items of correspondence that went unheeded, the courts are unfortunately clogged up with a great number of private parking charges, and in many of those cases, the unfortunate reality is that often the defendant will simply ignore the provision of parking charge notices or indeed correspondence relating to them. Obviously, the case of Beavis in 2015 established that there was a contractual right to recover these charges, but it doesn't change the fact that people are very, of course, anti-private parking charges and will often simply ignore them. Now, in this case, of course, DJ Iyer placed a great deal of weight upon the 2 phone calls, and the error in his judgment that was appealed to Her Honour Judge Evans was, in the first place, that he deemed that those 2 phone calls were sufficient to put the respondent on notice that he had vacated the service address. Now,
Well, sorry, you describe it as the service address. That is the address at which they chose to serve him.
yes, indeed, my lord.
Because that was the address on his driving licence.
Yes, held by the DVLA.
Yes. Okay. Can we look at the district judge's judgment?
Of course.
The district judge certainly had a witness statement from Mr. Carr. Did he give all evidence?
I'm afraid I'm not aware of whether he did, my lord. I wasn't at the trial, or at the hearing even, but I would suspect not if it was a set-aside application,
Right.
not normally.
Well, we have it's either page 79 or 81 of the bundle, depending on which numbering one's following. But anyway,
Yes.
The district judge's judgment, paragraph 2. Where the claimant has reason, he quotes 693, where the claimant has reason to believe that the address of the defendant is an address at which he no longer resides. The claimant must take reasonable steps to ascertain the address of the defendant's current residence or place of business. And the judge says in the last sentence of paragraph 2, I find that ringing them up and saying, I'm a tenant here, you can have a right to park here, that should have told them that he was not living at 119 Hale Road, that he was living at the apartments. What's wrong with that as a finding of fact?
Well, in my submission, my lord, that is based on the evidence before the court on that day, and with specific reference to the 2 phone calls. In the first instance, the phone calls themselves say, sorry, the first phone call in August 2018 I did actually include a screenshot of those in my skeleton argument. But the first one simply says, it states, he stated he has never received a permit, but his tenancy states he can park. Now, the second phone call, then on the 5th of October, doesn't mention a tenancy at all.
No, but let's concentrate on the first.
Yes. It's my submission, my lord, that the simple mention of a tenancy permitting him to park is simply insufficient to conclude that that was his normal everyday address. There are plenty of instances where individuals have second addresses. He may have been a landlord subletting the property. The reasonable steps referred to by CPR 6.93 were, in my submission, complied with by virtue of the inquiry with the DVLA. And it was HS...
Forgive me, that's not logical, because the DVLA is what gives you the address, isn't it?
Yes.
And then the question is there reason to believe he is not at that address? So inquiring, finding out that he's at that address isn't an inquiry, is it, as to whether he's at that address? Because that's how you found out he was at that address in the first place.
I'm sorry, my lord.
Well, the reason you have got the address,
Yes.
is because you made an inquiry of DVLA.
Yes, correct.
And then, when you get the phone calls, the question is, does that give you reason to believe that he may not be at that address? And so you can't then say, well, yes, we did make reasonable inquiries because we asked DVLA. But that's how you've got the address in the first place. So that can't be a reasonable inquiry as to whether he is at the address that DVLA gave you.
I take the point, my lord, of course, but at the same time, in this particular case, excuse me, it's my submission that the evidence that was before DJ Iyer in respect of him simply mentioning he had a tenancy there was not enough to suggest that the DVLA address was incorrect. And it was on that basis that was pursued.
But that's not, sorry, I don't know what you mean by DVLA address is incorrect. The judge found that that accepted what it said in Mr. Carr's witness statement, that he rang the company and had this conversation. Now, the judge could have found Mr. Carr's a lying toe rag, and I don't believe a word of this, and this is yet another case in which somebody's been issued with parking notices and has chosen to ignore them, but he didn't. He found that the phone call was made, and ringing up and saying, I am a tenant here, and I have a right to park here, although, as he said in his statement, he doesn't have a permit. What I don't understand is why that does not give the claimant reason to believe that the address at which they had served him is an address at which he no longer resides.
Well, my response to that, my lord, would be that if we return to the basis on which the appeal was granted by Her Honour Judge Evans, it was her finding that DJ Iyer essentially erred and made a finding that was inappropriate to make, because what Mr. Carr said on the phone call, and the only evidence before the court at any point of what he said in the phone call, is his tenancy states he can park here. It's my submission that that doesn't necessarily mean, and it doesn't push things far enough to put anybody on notice that that was his permanent address. Just because someone has a tenancy does not, in my submission, mean that that is necessarily the address at which they normally reside.
But that's not the test we have to, the judge had to consider was whether or not, in finding as he did, the Deputy District Judge made a finding which wasn't open to him on the facts.
Indeed, my lord, of course, and it's my submission that that was the correct decision by Her Honour Judge Evans on the basis of what she states in her judgment.
All she says, the only reason she gives in paragraph 12 of her judgment is that the judge referred to 2 telephone calls, but in fact he only referred to tenancy in one of them. That's the only reason she gives, no other reason.
Yes, and it's that, my lord, which we submit is the error that led to a finding being made that shouldn't have been open to the Deputy District Judge to find, because he's expressly referred to 2 phone calls. Her Honour Judge Evans also referred to 2 phone calls, but concluded that only one mentioned any sort of tenancy. She also suggests that there could have been an eventuality where DJ Iyer may have decided differently had he concluded there'd only been 1 phone call as well relating to a tenancy, which there was, as a matter of fact. And it's on that basis that we say that the decision of Her Honour Judge Evans was correct in overturning that finding of fact, which was based, in my submission, on extremely tenuous evidence that was open certainly to interpretation, and that the respondent could have done no more and needed to do no more in order to comply, to take means.
You just said the key words, I think, open to interpretation. And that's what the judge did. He interpreted it.
I understand.
As it's open to interpretation, it was open to him to interpret it as he did.
Of course, my lord, I understand that, but
that's the end of your appeal then, isn't it? If it was open to him to interpret it as he did, then that's the end of it.
I would respectfully disagree, my lord, because this appeal is, of course, from Her Honour Judge Evans' decision, and the test she had to employ, of course, was one where there is a high bar. I acknowledge that DJ Iyer interpreted it in a certain way, but we say there was a fundamental underlying mistake that led him to that, because he expressly noted that there were 2 phone calls. And
can you look at the second phone call then?
Of course. Which it seems there's 2 entries on the 8th of August. I don't know whether they're 2 separate calls or not. Perhaps not.
Well, I think it's the second. I mean, what came into the second one is the 5th of October call, isn't it?
Yes, indeed. So motorist call stated he has a letter from the client confirming PCNs issued incorrectly, asked to email litigation.
Well, what do you understand by that? What he's saying, what they're recording is that Mr. Carr rang and said he has a letter from client, that's the landlord.
It would be, yes. The landowner, I think.
Telling Mr. Carr that the PCNs which had been issued were issued incorrectly. Well, that can only be because he's got a right to be there.
Well, my lord,
Was that from the notes, which
but we haven't seen a copy of that letter, of course. And to my knowledge, the evidence of that was not before the court. It may well be, and Her Honour Judge Evans did later on in her judgment suggest that she believed that there may be a defence to the claim, and of course the promptness matter was element was fatal to that in her judgment. But in that respect, that would fall within the defence of the claim as opposed to service of the claim. Now, it may, in respect of any letter from the landowner, that hasn't been produced, so we don't know what it said.
no, I think you're misunderstanding. I think the point is, doesn't that 5th of October phone call, when understood in the context of what had been said on the 8th of August, also refer to the fact that he has a right to park there as a tenant?
I would submit, my lord, in response to that, that would be an extreme leap to take.
Why? He's already told your client that he's a tenant there. And then he's calling up saying he's got a letter from the client, who he's already told you is his landlord, confirming the PCN's issued incorrectly.
Well, I would repeat the submission, my lord, that that still doesn't necessarily mean that the address relating to the PCNs was his normal, everyday abode. It's a question of service and the reasonable steps that could or should have been taken. Now, DJ Iyer, in his judgment, doesn't delve into the meaning of that second phone call. What he seems to state is a blanket approach to both phone calls, saying they both notified of a tenancy, whereas they clearly only one mentioned a tenancy. And I submit that is not enough, and that the only reasonable steps that the respondent could have taken in those circumstances were to attempt to find an address from the DVLA, which they acknowledge they did twice, although the second time they were refused because of DVLA guidelines.
Well, as two things. One, the district judge in the last sentence of paragraph 2 does not refer to 2 telephone calls. He just says, I find that ringing them up and saying I'm the tenant here. And that was a finding that was open to him on the basis of the first phone call alone. The second matter is that in paragraph 3, he finds that it would have been reasonable, for example, to have contacted the company that they provided the services for. So he says just going to the DVLA was not sufficient. Was that also a decision open to him?
I would submit, my lord, that no, it was not properly open to him. Again, I apologise for repeating myself, but I return to what I would submit is the very tenuous evidence in response of notification.
No, sorry, paragraph 3 is a different point. Paragraph 3 is assuming that you had reason to believe that the address of the defendant was a different address, that just going to the DVLA was not sufficient. You must take reasonable steps. And the district judge found that your contention, or your client's contention, that going to the DVLA was sufficient, was not sufficient. And reasonable steps would have included, for example, contacting the company that you provided services for. What I'm asking you is, what's wrong with that as a conclusion?
I would submit, my lord, that the difficulty with that conclusion is that, again, as I said, I do apologise for repeating myself, but that it was born out of a very vague and tenuous disclosure made by Mr. Carr to the respondent, simply saying his tenancy states he can park here. I take the point that your lordship made regarding the other phone call and its interpretation, but I repeat that that is an extreme leap to take. And in respect of the reasonable steps that should have been taken, simply saying his tenancy permit him to park there is lacking a great amount of detail. He states he has a tenancy, and I hate to sound pedantic, but that is not the same as saying I am a tenant here. It doesn't say he lives here. And it's on that basis that I submit that it was inappropriate for DJ Iyer to, on the basis of such, in my submission, tenuous evidence, conclude as he did, which then, of course, led to Her Honour Judge Evans upholding the appeal, the first appeal. So essentially it comes down to the evidence before the court, which obviously I've stated in my skeleton as well, was in my submission simply insufficient to allow for that finding to be made, which is why I submit that Her Honour Judge Evans' decision was in fact correct. And I'm not sure I could assist much more on that point, my lords.
Well, we're at the moment we're only focusing on ground one.
Of course.
But if the appeal is successful on ground one, then ground two doesn't matter.
Yes.
Mr. Yamba might be in some difficulty if he had to rely on ground two. Is there anything else you'd like to say on ground one?
I don't believe so, my lords. There's obviously I've outlined the various authorities on which I rely. I know they're not all are binding, but they're certainly persuasive in my submission. It would seem probably a waste of the court's time to go through them orally when they're all in writing. So unless your lordships have any further questions, I'm not sure I can assist much further.
Thank you very much.
Thank
We'll retire to consider what you've said.
Court has the table. advisor favourable?
Do sit down. Mr. Yamba, we're very grateful to Mr. Craggs for his valiant submissions in support of the decision of Judge Evans, but we need not trouble you in reply. The order will be that the appeal will be allowed and the decision of the district judge restored. We will give our reasons for that in writing in due course. We'll send out a draft in the usual way. That is a draft not for re-argument, but just correction of typos and errors of dates and so on. And the contents of the draft are confidential to the parties and their legal advisors until the final handout. Mr. Yamba, do you apply for costs?
Yes, Your Lordship, yeah.
Mr. Craggs, we briefly discussed this. It seems to us you can't really resist an order for costs in principle. We wouldn't propose to assess them today.
Absolutely, my lord. Yes, I appreciate costs follow the event.
Yes.
And yes, in terms of the assessment of them, we've got 2 schedules. So yes, perhaps another day for that may be
Yes.
the best course.
In a way, one doesn't have to wait for the written reasons. Would you like to make submissions in writing in the next 7 days as to what you say? If the parties can agree the quantum of costs, that would be great. But if not, if you make submissions as to what you dispute in the claim for costs on behalf of Mr. Carr, and then Mr. Yamba can reply and we'll deal with the whole thing on the papers.
Yes, of course, my lord. I'll absolutely do that. We will try to endeavour to agree, of course, and if we can't, then we'll do that.
Yes, the order would be that the company has to pay the claimant's costs here and below, would it not? Before the circuit judge and also before the district judge, because this isn't a small claim, is it?
I'm not entirely sure, my lord, of what track it ever got allocated to.
It was not located, my Lord, if you may assist. It wasn't.
It wasn't allocated to a
Yeah.
track.
Yeah.
No. And some costs were originally ordered and paid, and then there was an order for repayment. I'm looking at the district judge's. The district judge's order is at page 83. That order, we would restore that order, including all the costs of 175, but the application which you make for costs, not only that should be restored, but the company should be ordered to pay the costs before us and before the circuit judge, and that's what we'd invite submissions about.
I'm grateful. Grateful, my Lord.
Thank you, my lord. My lord,
Yes.
I have very explicit instructions.
Yes.
That should today's appeal be successful,
Yeah.
I am instructed to seek leave to appeal this decision
To the Supreme
to the
Court.
Supreme Court. Yes,
Right.
indeed, my lord.
Well, you'll need the reasons for that.
Yes. I'm simply, sorry, I apologise. I'm simply just ensuring that all parties are aware that those are my instructions, and I appreciate we'll need the reasons for that in order to do so. But yes,
We will, yes. Yes. Do we say anything about time?
No, because it,
We can't give an extension, can we?
no, but it,
We are not yet dismissing.
Right, well, we will say that our order is not to be drawn up until we give reasons. So all we have done is intimated that that is what we are going to do. And then we'll issue an order including dealing with costs.
I'm most grateful,
in
my
due
lord.
course.
And then the 21 days for appeal would run from then, of course. I'm grateful.
I think so,
I hope so.
yes.
Thank you.
Yes. Right. Thank you.
Thank you.
All rise in favour.